stand by while NCLA cuts through the noise to signal abuse of administrative power. This is Administrative Static with Mark Chenoweth and John Vecchione.
Welcome back to Administrative Static. I'm here to discuss something that has appeared a lot in the legal press, and that is having to do with our client, Judge Pauline Newman of the Federal Circuit. And as many of you may know, there has been a proceeding to judge her fitness that the Federal Circuit has started, Judge Moore primarily. And Judge Newman has asked that it go to another circuit because they're all witnesses there. They're almost a judge in their own case, certainly. And we filed a case in the district court to have this done. But the Federal Circuit, it's really unbelievable that this hasn't been moved to another circuit. And I'll tell you, the National Law Journal, there's just so many articles. I have not seen one article by a third party, somebody who's not in the Federal Circuit's ambit, who can even fathom why this matter has not been sent to another court. You know, nobody should be a judge in their own case. The Romans knew that, and I think that if the Romans, who were not a bunch of softies and didn't have our modern views of right and wrong, knew that you can't be a judge in your own case, certainly I think that Judge Moore should know it. But they plod on, and what they've done now is issued a ruling this week saying that, oh, well, now you have to sit for an examination on our terms, and you have to submit to us, and it's time to do that. And then they've put all these allegations that Judge Newman can't respond to in this particular form, which are, one of them is that she thought that somebody who's been dead for a while is alive, when I'm positive that all she did was say, well, that was the procedure at that time. But there's all kinds of allegations in here, and I'm not going to discuss them directly. The time will come for that. But it has been the case that Federal Circuit is putting all of this material out there and then saying, oh, but you can't talk about this, that, or the other thing. Now, I'm only going to discuss what's in the press and what's out there already, but I don't think this is a way to run a railroad. And so what is I'm just going to talk about the state of play, because under the judicial examination of this under the law, it has been not used too often. This doesn't happen a lot. And so it's been moved, and when it does happen, it is usually moved to a court that isn't, the court making the rulings and the statements. The other circuit investigates and takes this type of information. So I think that the various allegations that have been made here, they don't have any statements by Judge Newman's supporters, who are legion, and those haven't gotten in there. But again, we are somewhat the legal matters are addressed in legal pleadings in places like this. But in any event, we've had Judge Newman here, and certainly from my observations, this is all does not comport with my experience. Let's put it that way. So what's going to happen here? It strikes me that what is needed is a fair tribunal. That's the first thing. So Judge Newman is 95 years old. She's been on the bench. She was the first person appointed to this bench when the court was reconstituted or created. And this bench primarily deals with patents, things like that. And as recently as 2020, I took a look this morning, Judge Newman's dissent was upheld by the Supreme Court, and the judges who were in the majority on the federal bench were shown to be wrong, even that recently. And I understand some patent cases were released by the Supreme Court today, so I haven't looked at those. But the idea that that this is about her disability strikes me as unlikely, because what we have here is somebody who's high functioning and who has merely asked that all of these allegations, make all the allegations you want, but let's have it done in a place where the witnesses aren't the judges. And that's pretty much what's going on here. And I have taken a look at some of this, and here's the problem with this whole procedure. The Constitution provides that a federal judge is appointed for life for good behavior, and that in order to remove a judge, you have to impeach them. And it's been happening. I mean, a friend of mine clerked for Alcee Hastings, and Alcee Hastings was impeached. Then he went to Congress. Didn't seem to hurt him much. But one of the articles has a statement by Congressman Jordan's, who's the head of Judiciary in the House. And he chairs the House committee that would do any impeachment, and says, Judge Newman is an exemplary jurist who has long stood for the Constitution and earned every right to keep her seat on the bench and make decisions about her future herself. Jordan's spokesperson, Russell Dye, said in a statement to Bloomberg Law. And so they have, the Federal Circuit has made these allegations that Judge Newman is not working with technology well, and is, I guess they say, paranoid here. Well, if you look at what the Federal Circuit has done, and that they won't let any other judges in the country judge this dispute, that seems to me not paranoid, but a reasonable suspicion that the course of neutral law is not being followed. I guess they could call me paranoid. So I think we're going to see, we have filed in the district court to move this and stop the way they're doing it right now. And as I said, we will address it. But one of the things about patent law, and I think something that is suffusing this a little bit, is that whether or not you uphold patents is obviously can be worth millions, if not billions of dollars. And so I think many of the patent holders and the people who are for strong patent rights and intellectual property rights are seem to be supporting Newman. And I have to tell you what I've told everyone. I am not a patent lawyer. I do not pretend to be one on either the radio or TV. So I am not someone who knows all the ins and outs of this, but it certainly seems from these articles that have appeared in the Daily Labor Report, in Bloomberg, in National Law Journal. I mean, they're everywhere. People are talking to the press, and the press is interested in this. And I think one of the reasons is how important patents are to our prosperity and to our constitutional structure, because not every country has what we have, which is in the Constitution, there is a section that says Congress may issue patents to help the dispersal of scientific knowledge and the advancement of it. And so the American patent system is the best and the most used in the world. And the Federal Court of Claims is the place where all of these disputes, whether or not you have a new a new patent, or if it's been done before, or if you've waived a right, or any of the various things you can have to challenge a patent or uphold a patent are done there. And unlike some of the other areas where we talk about in administrative law directly, which is that we have this constitutional issue or that constitutional issue, and people who are interested in that look to it. Everybody in the tech business and everybody in, I think, Wall Street looks at what comes out of the Federal Court of Claims. It's a high stakes place for people who've put a lot of chips on the board for this sort of thing. And so I don't think, and there's no way to fix the problem except by moving this dispute to another court. And all it would be is that you just say, well, we have witnesses here because we're judges who have seen her, and this is what we've observed. And she says what she's actually happened, and she gets her witnesses. And then the investigation is done by a court that is not already involved, is not the accuser, and is not the witness. And that's just reasonable. And what I analogize this to is that if you're in the wrong court, let's take a look at what just happened in the Axon case. The Supreme Court came out, which we call the Cochran case here. They were put together by the Supreme Court, but New Civil Liberties, we had the Cochran case. Well, if you had to go through that adjudicative process for your constitutional rights, you've already been injured. If you're in the wrong forum, if you're in a forum that shouldn't be deciding this and can't decide it because of conflicts or for anything else, then you've already been injured. So let's take first things first. Let's get this whole dispute moved to any federal circuit that's not the federal circuit, and I guess to another bench, and then we can proceed. Anyway, we'll be following that case. Welcome back to Administrative Static. This is John Vecchione, and I want to talk about another of our cases, which is the Federal Trade Commission versus Precision Patient Outcomes and our client, Margrett Lewis. But now we have filed, as of this week, counterclaims against the FTC, and I'll give you a little background about this. So in this case, the FTC has moved under Emergency COVID Act, said that the selling of dietary supplements, largely vitamins, things were said about the vitamins that are deceptive in some way. So that's the claim. But they have moved in the Northern District of California, which in this case is San Francisco. Sometimes it's Oakland, sometimes it's, I think, Sacramento, but San Francisco for this particular case. And we moved to dismiss, and the court found against us on that. And so we have filed our answer and counterclaims. And I think some of you out there might be interested in it because I know that Black Knight and I think it's International Enterprise. Anyway, they have filed a suit against the FTC saying that it does not have the power to prosecute because of the way it's structured. But these cases have not come fast and furious since 3 weeks ago when the court said you could bring them in district court even if there was an administrative hearing. Here, we did not have an administrative hearing. The court, the FTC moved against our client after she sent them a letter telling them what she planned to do. And they have followed it closely since then and brought an action against her eventually after she stopped selling both products, COVID resist and virus resist, that they didn't like. But anyway, that's the FTC for you. But I want to explain the action that we've brought because it really touches on many of the problems with administrative law. There is a case from the 30s, Humphrey's Executor, which said that what the FTC did then, sort of investigating certain things and bringing matters in their own proceedings, was quasi-judicial and quasi-executive, is what Humphrey said, and said, we think that the structure of the FTC is okay, and because of the powers that it has now. But we've had almost 100 years of Supreme Court precedent emerge since then, and I think wrong on the day it was decided, but it certainly is wrong under the current analysis of the Supreme Court that executive agencies have to be in control of the executive. We do not have a system whereby there is just a bunch of untouchable experts who get to dictate to Americans how they should live with no direct control by the president or even the Congress. So what's going on here? Well, we have 3 claims against the FTC, and we cite right at the outset the most recent pronunciation by the Supreme Court on the FTC. The Supreme Court, this is paragraph 1, has noted that challenges to the combination of prosecutorial and adjudicatory functions in a single agency, including the FTC, are, quote, fundamental, even existential, unquote. Axon Enterprises versus Federal Trade Commission. Challenge in Axon as is here is in, quote, in essence, the agencies as currently structured are unconstitutional in much of their work. So Axon is the FTC and Cochran is the SEC. And then we go on to say the FTC is run by a multi-member body, all of whom are not removable by the president except for cause. They have chosen to press cases on deception claims by litigation rather than regulation. And so what's going on there is that you have a multi-member body. They're staggered. So no one president is not supposed to appoint them all and can't fire them unless he can find, the robin from the tail or something. So let's look at the Justice Department. Justice Department has concurrent jurisdiction with a lot of these things. Well, Merrick Garland can go tomorrow if President Biden says to go. And the Justice Department is our oldest law enforcement department. Well, I guess the Coast Guard would argue with that, but I think it's law enforcement and it's the oldest, and it has a different structure and a different way of acting. And I don't think most people think that no one that I know challenges the Justice Department's constitutional structure. It was in the Judiciary Act, the first Judiciary Act of 1789, if I'm not mistaken. It's like one of the first cabinets. There's like Justice Department and their state. In any event, by law, the Justice Department, the Chief Law Enforcement Office of the United States, must assess whether it will bring an action of this sort before the FTC can. Justice Department has chosen not to prosecute this case. And we say that represents the judgment of the executive in a properly constituted agency. And then we ask, this court should declare the FTC's structure and procedures unconstitutional, and join the FTC from prosecuting this action and dismiss the case. And we then go into what we're complaining about. And what we're complaining about is that there is a huge separation of powers problem here with the FTC. Constitution sets out 3 branches of government, vests each with a different power: legislative, executive, and judicial. Now, if any of you folks who saw Schoolhouse Rock would know this, and I think they still teach this, and it's still in the Constitution, hasn't changed. To exercise that power, the Constitution directs the president to, quote, take care that the laws be faithfully executed. And why is initiating suit? What is that? What box does that fall into? Is that a congressional action? Is that executive action? Or is that a judicial action? Well, it's just has always been, is now, and ever shall be an executive action. Initiating a lawsuit, right here, is the essence of, quote, taking care the laws be faithfully executed. And that responsibility is entrusted to the president. And then we cite Supreme Court cases. The entire executive power belongs to the president alone. That's seal of law from 2020. And it includes the power to initiate lawsuits, we say. So what you have there is, I think, unchallengeable statements of how our government is structured. And then we cite Myers and Cunningham. These are other cases about removal of officers. The president cannot fulfill his role of faithfully initiating lawsuits without the assistance of other agents. He must select those who are to act for him under his direction in the execution of the laws. The president's selection of administrative officers is essential to his execution of the laws. It's all Myers. Equally essential is his power to remove those officers. Told otherwise would make it impossible for the president to take care the laws be faithfully executed. And that's not me, that's the Supreme Court. And then even more recently in 2010, since 1789, the Constitution has been understood to empower the president to keep his officers accountable by removing them from office if necessary, unquote. And so what's happened here is that the FTC is not issuing a quasi-legislative or quasi-judicial function. I misspoke before. That's what Humphrey's executor says. The commission has taken legal stances directly contrary to those advanced by the executive branch. And they do this a lot. The FTC differs with the Justice Department on a number of issues. I think now they're trying to get their antitrust ducks in a row. But oftentimes the FTC goes in a different direction from Justice Department, which I think you've heard me on this show before. I think it's scandalous. I think you can't have an executive at war with itself. You have a single head and it has to be directed in a single manner. And when the agencies fight, the president then decides who wins. You know, you always see these scenes in all the movies, even Air Force One, where people who are in charge of different parts of the government are arguing what the best course is, and the president's got to decide it, right? Well, it's not just Harrison Ford, it's everybody. And that's how an agency is supposed to work. We note that these folks aren't accountable directly to the president because they can't be removed. And we then go through some other problems because there's other constitutionally sketchy things going on. One is we think that one FTC executive wasn't even there when this was decided to go forward with. And so that's a problem. It's also a problem that we don't know. The litigant doesn't know how the Justice Department and the FTC have separated who gets to prosecute you, or the FDA. The FDA can bring stuff to justice on dietary supplements as well. So there's no intelligible principle that the Congress has set out for how that's supposed to be done. So we say there's a non-delegation problem. And what we have here is basically 3 counts. And the first count is all of what I just related. PPO's and Margrett Lewis's constitutional rights are being affected, and so this suit should be enjoined. And then violation of the non-delegation of legislative powers is count 2. And count 3 is violation of due process, being what we call, it's called in the law, in the press, the zombie votes. Basically, you say someone's voted who's already out of office. So I think that this is going to be interesting going forward. I think that you'll see other cases like this emerging. The FTC is in the crosshairs of a lot of folks because of its structure and has been for a long time. But it's also, I think, fair to say that some of the new things they're doing have drawn more fire as well. But the old thing is what we're attacking here, is that it's not constitutionally structured. And we'll let you know how it goes. And we'll be back next week with Mark, and we hope you'll join us. Thank you.